Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is, can the Federal Trade Commission use rulemaking to change the antitrust laws? A closer look at the administrative law challenges with Professor Richard Pierce. In an earlier episode of our Curious Amalgam featuring Professor Adam White, we explored how the FTC rulemaking process works and how it's been used by the FTC. In this episode, we will dig a little deeper to better understand potential challenges the FTC may have to utilize rulemaking to accomplish certain of their stated goals. Joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Christina.
So who is our guest today?
Our guest, Professor Richard Pierce, is a renowned scholar and expert on administrative law and government regulation, currently teaching at the George Washington University Law School as the Lyle Alverson Professor of Law. Professor Pierce has authored over 20 books and 130 articles and counting in his area and has been cited in hundreds of judicial opinions, including a dozen opinions of the United States Supreme Court. Most recently, Professor Pierce has written about the FTC's proposed use of rulemaking to change antitrust laws in articles, and an upcoming book chapter where he discusses the specific challenges in areas where the current FTC leadership proposes to change antitrust laws. So we are very happy to have Professor Pierce here.
Welcome, Professor Pierce.
Thank you, Christina. It's a real pleasure to join you to discuss this important topic.
Sure, pleasure is all ours. Professor, before we go any deeper, and we know we have a lot of depth to cover today, let's just make sure, what kind of rules in the rulemaking are we talking about? Essentially, what kind of documents, documents of what kind of legal effects are we concerned with?
Well, there are three basic kinds of rules. There are interpretative rules, there are policy statements, and then there are legislative or substantive rules. The interpretative rules and policy statements the FTC has been issuing for decades, and they can be very, very helpful. They're pretty easy to issue. They can be issued fairly quickly. They require only a modest commitment of agency resources, but they lack the force of law. And they're also easy for a new administration to reverse when it takes office. Legislative rules are completely different. And these are the kind of rules that Chair Khan wants to issue. They have the force of law, but they can only be issued through a notice and comment process that typically takes several years to complete and requires a commitment of significant agency resources. But they also have the advantage that not only are they legally binding, but there's actually quite challenging for a new administration to change. So they tend to have greater permanence.
Sure. So in short, we're talking about legislative rules in contrast to interpretive rules and policy statements. So these legislative rules, is that also right that courts sometimes are used to confer, I guess, more deference to legislative rules?
Yes. For the last, over 30 years, the Supreme Court has applied a doctrine called the Chevron doctrine that it often applies to legislative rules, and it has the effect of conferring on the agency a higher degree of deference than otherwise would be the case. But the significance of the Chevron deference doctrine has diminished tremendously over the last few years, so it's not a very big factor anymore.
Sure. I'm just going to leave the fun of Chevron deference doctrine all aside from memory of all students of administrative law. But let's focus on legislative rules a little bit more. So is there anything that you can actually agree with Chair Khan, who is the current leadership at the FTC, in her vision of using rulemaking, specifically legislative rules, to change U.S. antitrust laws?
Well, the use of rulemaking generally certainly can have big advantages. I agree with Chair Khan there. It's capable of creating much more clear standards of conduct. It permits broader participation by members of the public in the decision-making process. It provides a basis for more efficient and effective enforcement, and it can sometimes be capable of changing the law more rapidly than just a series of adjudications. Um, so I generally agree with her that rulemaking can be quite useful for an agency. I also agree with her criticisms of the process of adjudication. It's slow and cumbersome. It does not yield clear standards of conduct. And it undermines effective enforcement, makes it expensive, and then calls on generalist judges to analyze and to apply technical economic concepts with which they're not very familiar.
It's all in relative terms, right? Like rulemaking, even though we're talking about informal rulemaking as deeply discussed in the episode with Professor Adam White, is already a very long process. And then adjudication process, you're referring to the FTC administrative law judges, I guess, proceedings, right? And also court proceedings. They're all very in relative terms.
That's absolutely right. Both notice and comment rulemaking and adjudication can take quite a long time, and both require a lot of commitment of agency resources. One difference, though, is that at the end of the rulemaking process, you do get much greater clarity, and you get standards that are much easier for courts to apply in individual cases.
I think one of the criticisms, about the adjudication process, and I think you have agreed in some of your articles about, I guess, with Chair Khan in her criticism of adjudication under the rule of reason standard, right? Is that something that you can elaborate a little more?
Yes, I would agree with her here too. That generally speaking, the rule of reason, which is the approach that the Supreme Court takes to the vast majority of allegations of anti-competitive conduct, is extremely demanding. It takes many years to go through a proceeding that to which the rule of reason applies. So it's quite a difficult, demanding, time-consuming, resource-intensive procedure.
True. And I would like to know that you, in articles, also pointed out that these criticism of the rule of reason must be qualified, I guess, based on well-documented limitations. I guess both rulemaking and per se rules, right?
Yes, the biggest difficulty with rulemaking is that it does not work if you're talking about some pattern of behavior that can sometimes have good effects and sometimes have bad effects. Well, rules just simply aren't capable of addressing situations like that. There's really no substitute for case by case adjudication and application of some form of the rule of reason. And unfortunately, that's the situation with respect to most patterns of behavior, that they sometimes have good effects and sometimes have bad effects.
True. And then I guess let's pivot a little bit. Suppose there is room to improve the U.S. antitrust laws, and suppose that FTC rulemaking does provide a possible way to make such reforms, as we have just discussed. What really stops the FTC leadership from making legislative rules? What legal difficulties is the FTC facing?
Well, first you have to have a statutory basis. Congress has to have conferred on the agency quite clearly the power to issue rules. Chair Khan relies on two sources of authority to support her belief that the FTC has the power to issue rules to implement to define unfair methods of competition. as that term is used in Section 5 of the FTC Act. And both of those sources are quite dubious. I'm skeptical that the FTC can prevail in convincing courts that it has that power. One of the sources is a 1973 decision of the D.C. Circuit that holds that the FTC has that power. And the problem with that authority is that the court used a method of statutory interpretation that is inconsistent with the methods of statutory interpretation that the Supreme Court uses today. So I'm quite skeptical that the Supreme Court would uphold that opinion today. And then the second source is a very strangely worded provision of a 1975 statute. And I have to say, it's very hard to figure out what Congress had in mind when it added that brief bit of statutory language. But it seems highly implausible that in a statute that was intended generally and had the effect generally of significantly reducing the FTC's rulemaking power, that Congress simultaneously intended to endorse the D.C. Circuit opinion of 1973 and say that the FTC has that power. So I'd rate the FTC's chances of prevailing on that critical issue of whether it has the power to issue legislative rules to define unfair methods of competition at no better than, say, 30%.
Well, thank you for the mathematical guess on that. So just to recap a little bit. So the argument is that essentially Congress has arguably never given FTC the power in 1914, or has actually later in 1975 taken away the power to actually make legislative rules by the FTC, right? And then the two grounds that you think the current FTC leadership has to stand on is, one, the DC Circuit opinion in I guess the 1973 case called the National Petroleum Refiners, and then the 1975 Act that we've been talking about, nicknamed the FTC Improvement Act, right? That's really shaky grounds in my assessment. But is that all? Like, is there any other disadvantage of rulemaking, I guess, against other possible approaches to reform that the FTC, I guess, need to consider?
Yes, there are a couple. One is you really have to figure out what you want to try to accomplish through use of rulemaking. And what Chair Khan has indicated on several occasions that she wants to accomplish is she wants to make very large changes in the existing law. She really does not like most of the antitrust doctrines that exist today. And so she wants to try to use rulemaking to change antitrust law in very significant ways. And the problem is that any such effort will go to the courts. And the courts have already spoken on all of these issues. And the fact that she's now relying on a different statute, the FTC Act of 1914, rather than the Sherman Act or the Clayton Act, and it has slightly different wording. I don't think that the courts would pay any attention to that whatsoever. I think they already have decided what these doctrines should be, and there's no way that they would uphold a rule that says we hereby, by rule, adopt the opposite of what the Supreme Court, has said is the law.
I would just drop a note that a lot of this case law interpretation or readings of cases that would support Professor Pierce's argument, I guess they're all in the great articles that Professor Pierce has recently published. So I welcome our audience to read all that. Let's pivot one more time. So there are signals that the FTC leadership wants to potentially make rules actually in several very specific areas. And you have in your article, discuss them as demonstrations why the legal challenges would prevent FTC to actually go into those areas, make the changes that has been proposed. Can we talk that a little bit more? Why do you think most of those areas cannot be fruitful, experiments for rulemaking for the FTC?
Sure. So Chair Khan has actually referred to at least a dozen aspects of current antitrust law that she wants to change by rule, but I chose three of them to make a point. She'd like to create a right to engage in self-repair or to use an independent repair shop instead of repairs by a manufacturer. She'd like to issue a rule that redefines predatory pricing and a rule that outlaws, or at least presumptively outlaws, what are called reverse payments in settlement of patent disputes between brand name manufacturers of drugs and generic manufacturers of drugs. And what I do in that part of the book chapter is I go through the way she thinks the law should be, and I go through what the Supreme Court has said about each of those areas. And there's just no question at all. The Supreme Court disagrees completely with her approach. So it doesn't really matter what procedural instrument she uses to present that argument to the Supreme Court. It's just going to say, no, we've already addressed these issues. And the answer is no, we disagree.
Is there any reason to think that the current Supreme Court justices would take a different view or a more aggressive view the other way, and making it less likely that FTC rulemaking is possible?
If anything, they would take a more aggressive view the other way. It depends on the issue involved, but in many of these areas, the Supreme Court has been unanimous in rejecting the approach that Chair Khan is proposing. So, while I'd say there's only a 90% chance that the Democrats would reject it, there's 100% chance that
it's not a partisan issue. Yeah.
So I would like to point out that there is one area, I guess you signaled that you think it's perhaps more fruitful or more hopeful for the FTC to make changes, and that is non-compete. Can you elaborate a little more? Why do you think that's an area where the FTC can possibly change the relevant antitrust laws?
Sure. The big difference here is that the law for centuries, you can go back to the British common law back to as far as long ago as the 15th century, and you can find cases that say that non-compete clauses are justified. Now, they clearly have anti-competitive effects. They are justified only in certain narrow circumstances. Well, they've come to be used in lots and lots of very broad circumstances in the U.S., like there are hamburger chains where you dare not quit your job flipping burgers at one place in order to take a higher salary job flipping burgers. There is absolutely no justification for non-compete clauses in that circumstance, and that has been the law for literally 600 years. So here, all the FTC would be doing is they'd be codifying what is already the law. Now, the reason that you don't see very many recent cases on this is that the FTC and the Department of Justice believed that state labor law would be adequate to to deter employers from putting non-compete clauses into totally inappropriate contracts applicable to low-wage employees. And they now realize that was an erroneous assumption. It hasn't been effective for that purpose. So what they want to do is make antitrust law far more effective for that purpose. And certainly creating a legislative rule that says that non-compete clauses are illegal as unfair methods of competition, except in certain narrow circumstances, would be a step in the direction of making enforcement of the prohibition on non-compete clauses in most contracts far more effective.
Assuming they cross the initial hurdle of being able to actually conduct legislative rulemaking.
Yes, and that's one of the reasons why I really think, even in that context, they would be better off using a combination of their traditional tools that we know they have. They have the power to issue interpretative rules. They have the power to issue policy statements. They can issue an interpretative rule that says, we hereby interpret Section 5 of the FTC Act to prohibit non-compete clauses except in certain circumstances, and then a statement of policy talking about how they intend to enforce aggressively this new interpretation, and then combine that with a couple of well-chosen high visibility enforcement cases in which they go after, say, a hamburger chain and make some newsworthy victories in enforcing the prohibition on non-compete clauses. I think that would be more effective, and it avoids the risk that they go through the lengthy, resource-intensive process of issuing a rule and then discover that they don't really have the power to issue legislative rules.
Right. And consistent with your observation about non-compete, I guess to think out of box a little bit and then to put the big picture back here, what would be a better roadmap, I guess, in the ideal world to reform U.S. antitrust laws without getting the FTC into any administrative law troubles?
Well, a couple of points there. One is stick with the procedural powers that you know you have. There's no point in taking the high risk of using notice and comment process to try and issue a legislative rule when there's a pretty fair chance that the courts are just going to say you don't have the power at all. So stick to the procedural instruments that you know that you can use, and then look for opportunities for incremental improvement. There are a lot of things that the FTC could do under Chair Khan's leadership that would move antitrust law in the direction that she would like to move it in, if she just does it incrementally instead of trying to make these bold, big, radical changes. So, for instance, just becoming more aggressive in going after employers who use non-compete clauses in circumstances where they're inappropriate. Following the lead of the Department of Justice and going after people who use anti-poaching agreements to harm employees and make cause the labor markets not to function very well, and then again move incrementally to become more aggressive in blocking mergers where there's a pretty high likelihood that the merger will have adverse effects on the performance of a market, and then try to persuade courts to apply what's called the quick look version of the rule of reason in a higher proportion of cases. Those are all incremental changes that I think are well within FTC's reach if it just decides to go the incremental improvement approach instead of the gosh, we want to change all the rules at once approach.
Yep. Yeah, and we're certainly seeing a good amount of all of that as well in terms of more aggressive enforcement, focus on non-competes and anti-poaching agreements, certainly at the DOJ. So a space where there's a lot of moving pieces, and obviously this rulemaking aspect is one that we'll want to keep an eye on as well. So really do appreciate your insights, Professor Pierce, and again, echo Anora's comment. Everyone should take an opportunity to read the literature on this, including Professor Pierce's articles on it. But Professor Pierce, before we let you go, we always like to ask all of our guests a couple of questions. The first is to tell us something about yourself that those that work with you professionally wouldn't know.
I like to spend all of my leisure time, a high proportion of my leisure time, wandering all over the world observing wild animals. I just think it's fascinating to see the way that wild animals, both individually and as societies, operate.
And what's the most interesting animal you've observed?
Oh gosh, there's a lot of candidates for that. I think penguins are fascinating. One of the two, when they have little ones, one of the two is always out fishing, and when he or she comes in, they do this new kind of mating ritual where they dance around each other in very cute ways. But they're also kleptomaniacs. They have these little nests made out of stones, and every time the neighbor isn't paying attention, the penguin steals a stone. It goes on just all day and all night.
That's great. And Professor Pierce, any advice you have for young professionals, young attorneys, students who are interested in doing what you do?
Sure. My first advice, no matter what you do, is choose a place of employment based primarily on the characteristics of the people that you'll be working with. If you work with people that you believe to be honest and competent and just nice, decent people, gosh, that's a whole lot better than in some friction-laden workplace. And the second is because the world is changing so rapidly these days, stay flexible so that you're in a position to change jobs and even change your complete direction of your career in response to the inevitable changes in conditions that you will encounter over a career.
The last 2 years certainly have taught us that, if anything. And now the last segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
You pick a number 1 through 10.
Okay, am I supposed to tell you or not?
Yes, sorry. Pick the number and I'll
6.
6. What is your favorite sport and why?
Oh, I love what the rest of the world calls football, and we in the U.S. call soccer, and particularly the English Premier League. I'm addicted to watching English Premier League matches.
Great. Well, Professor Pierce, thank you again for your time today. And to all of our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.